Welcome to the Probate Nation. People are living longer thanks to good health care and healthy lifestyles. Yet, as we age, not everyone remains as sharp as they were earlier in their life. Frequently, a loved one, a son or a daughter, is called upon to take on the responsibility of helping an elderly parent with their financial and medical decisions. But even more frequently, the parent has not executed key legal documents to formally authorize that assistance. Over the course of 2 shows, we will learn about the legal process available to acquire that legal authority as a court-appointed guardian and conservator if your parent lives in Prince William County. We are fortunate to have as our guests local attorneys with experience in these matters. They will serve as our guides about all that is involved, and along the way point out common pitfalls to avoid that often arise if you elect to board and ride on what we refer to as the living probate train. Our first guest is a partner with the Manassas law firm of Farrell & Croft. Her practice focuses on wills, trusts, estates, probate, long-term care planning, conservatorships, and guardianships. She also serves as a certified guardian ad litem for incapacitated adults. She is a member of the Prince William County Bar Association and the Virginia Women's Attorneys Bar Association, and she's active with Capital Caring. Our second guest is a partner at the Manassas law firm of Von Keller Thielen. His practice focuses on estate planning, estate litigation, adult conservatorships, and guardianships. He also serves as a certified guardian ad litem for incapacitated adults. He's a member of the Prince William County and Fairfax County Bar Associations. Please welcome attorneys Andrea Morisi and Joe Thielen. Well, guys, thank you very much for taking the time to appear today. Joe, I'm going to go right to you and focus on some of these key legal decision-making documents that are often overlooked. So what is the important medical decision-making documents that someone should execute?
So there are multiple documents that someone can execute for making medical decisions. You can have them be very broad powered or very limited, depending on what you're seeking to accomplish. Most people want to have an advanced medical directive or advanced healthcare directive that allows other people to make medical decisions for them. If they're not able to themselves, often it's a spouse or a sibling or a child, depending on how old the children are. And you give that person the power to make decisions for you for medical purposes when you can't. Other things that are important are often release of information, a HIPAA release, which you can grant to anyone that you want to have knowledge of your medical conditions and what's currently going on with your health. The other thing that you can execute is what we call a living will, which is a document that discusses your choice to have a dignified life and that you don't want to continue treatments if you aren't likely to recover from those treatments. And you can choose how strongly you want that worded and what type of treatment you do want to have.
So then what are some of the important financial decision-making documents that someone should execute before they become incapacitated?
So for financial issues, we would normally have someone execute a durable power of attorney. And this, once again, can be expansive or very limited. In most cases, it's important to find someone you trust and you give them all the power that you would have if it were you acting. You can choose to make it be effective immediately upon signing or at some future date, such as incapacity. You give as many or as little powers to the person as you want.
And Joe, so if people have executed these documents, will that preclude the need to go to court to get a guardian or conservator appointed?
The goal is that it will preclude the need for a guardian or conservator. If things work out well, it can preclude that, although there are some times that it is not sufficient. There are instances where a bank, say, won't take the power of attorney and will only take a court order appointing a conservator. In that scenario, you might need to go to court anyway. If the person who is appointed guardian, or the person who has the power of attorney or the advanced medical directive agent power aren't doing a good job, you might need to go to court to replace that person. So the general idea is that these will help you avoid lawsuits and litigation over guardianship and conservatorship However, it's not a guarantee that it won't ever happen.
So Andrew, let me turn to you. So, if someone's become incapacitated and they no longer have the ability to make medical decisions or financial decisions, and they have not, executed those documents that Joe had suggested should be in place, who can make those medical and financial decisions for them?
In the case of financial, there is no alternative. If they have not made arrangements with a financial institution ahead of time to name somebody or done a general durable financial power of attorney, they will have to go for a conservatorship. In the medical area, we do have a Virginia statute that allows doctors to work with particular family members to make end-of-life decisions. However, there's a question on whether that could apply to everyday decisions. For instance, can I consent to someone having a vaccination? The code would not cover that scenario, and you would need a medical power of attorney, as Joe discussed, to get those done.
So, Andrew, in the absence of these decision-making documents, are there legal proceedings that can be initiated to obtain the legal authority to make medical or financial decisions?
Yes. Guardianship is the proceeding where you would get authority over an individual, the person, and conservatorship is the proceeding you would get to obtain authority over financial. These can be, you can go for guardianship alone, you can go conservatorship alone, or you could go for them together. You could even have different people serving in each position.
Okay. Now, let's go, Joe, let's go ahead and turn to the process to obtain a guardianship or conservatorship. And let's start with the topic that, there's a formal process to initiate this request, and that's done by someone who wants to become appointed guardian or conservator. Now, let's discuss at the very beginning a very important issue, and that is the one of bonding. Do all guardians have to be, if I want to become conservator, I want to become guardian or conservator, does everybody have to be bonded in some way?
Yes. Everyone has to be bonded. All conservators and all guardians have to be bonded. The court wants to make sure that when someone is in a position of responsibility for another person, that they have an incentive and a reason to do what they are supposed to do and uphold their oath to that person.
So let's talk about the guardian. If someone wants to become the guardian, okay, can bonding become an issue in connection with having someone appointed to be a guardian?
Bonding is not typically a big deal when someone is becoming a guardian for someone, because typically the bond in such a situation is about $1,000 and is unsecured by a surety, meaning you don't have to put any money up front or have a licensed insurance agency to pay for the bond. So it's typically not difficult for someone to get to be bonded for guardianship decision.
So, but on the other hand, conservators have to be bonded as well. Could that pose a problem for them in attempting to be appointed a conservator?
It certainly can pose a problem because conservators are dealing with other people's money, and depending on how much money they have or the amount of money they have typically determines how much the bond amount needs to be. And those bonds are typically secured by surety. There are some smaller bonds that aren't required to be by surety, usually $25,000 less. But once you get above that amount for the person's estate, you end up in a situation where the person who is going to be conservator has to find an insurance agency that will provide the surety for the bond. Usually it's in excess of the total amount of the estate.
Okay. So Andrea, let's go ahead and turn towards the petition. We've gotten through bonding. We've figured out whether we can be bonded or not. And so we know we can be bonded. So the formal process to initiate a request for the appointment of a guardian or a conservator is through a pleading called a petition. The person making the request to the court is called a petitioner. So could you briefly explain to us what goes into the petition?
The petition is defined by, or the contents of the petition are defined by a Virginia statute. They're very detailed. The person who we're asking to go under guardianship is called the respondent. And we need that, the respondent's address, name, birth date. We need their social security number. We need information about the family, the structure of the family, and names and addresses of family members. We also need a medical definition as to why this person needs guardianship and conservatorship in the event of monies. We also need information about what the petitioner plans to do once they've become guardian or conservator over the respondent. Are they planning on making some changes in the person's location, putting them in a nursing home, etc.?
So, as you said, the person who we believe is incapacitated is called the respondent. So, is a medical evaluation of the respondent by a physician typically filed with the petition?
The medical statement is typically filed with the petition. However, if we have difficulty getting it, or it's in the works, we can initiate the petition and file it as soon as it's received. We're going to talk about a guardian ad litem, and they can also assist in obtaining a medical statement, say in the instance where you have an individual who doesn't frequent a regular doctor, so we don't have someone familiar with their circumstances. The statement is generally can be done from the doctor's notes. A separate appointment is not needed where the client or the respondent is known to the doctor. But in the instance of not, we'll need to arrange for something to be obtained.
And so that medical document, and I guess the social security number as well for the respondent, is that something that is filed with the petition, or is it filed under seal? Could you explain that, please?
Yes, we ask the court to file those documents under seal. These are not needed by the general public or anyone searching court records. This is just for the process. Social security number is needed by the court for some reports. And the medical statement, of course, is confidential. And the doctor is indemnified from releasing that information, part of the court proceeding. But we don't leave it to the general public. It's just internal to the lawsuit.
Okay. Joe, I'm going to turn to you now. So we filed the petition. We know we have bond. We need to have this guardian ad litem appointed as part of this process. How is the guardian ad litem selected in Prince William County?
Either the party, the petitioner's attorney will pick someone that they know is eligible to serve as the guardian ad litem, or they can file it without picking someone, and the court will choose someone off the approved list from the Supreme Court.
And what is the purpose and role of the GAL in this particular legal process?
So the GAL serves the respondent with the notice and all the appropriate paperwork as required by the statute. They do an investigation. They advise the respondent of the rights they have and what rights they're potentially going to lose. They write a report to the court making a specific recommendation as to who they think should be appointed as guardian and conservator, or both. It doesn't have to be the same person. It could be co-guardians. And to the extent that they need more information, they're entitled to do investigation to find financial records, or even request more medical evaluations if they think it's appropriate prior to making a recommendation.
So looking ahead to the court hearing, Joe, after we file the petition, how long before your request will be heard by the court and acted upon?
So once the petition's filed, it can take, typically as quick as it turns around is 4 to 6 weeks, but it can take more time if the parties need more time to do the investigation or if it's going to become a contested hearing. But generally speaking, the run-of-the-mill uncontested guardianship will take about a month and a half.
And when we actually get to the a hearing date, which has been noticed, who needs to appear before the court?
So the petitioner should appear, petitioner's counsel should appear, anyone who is proposed to be a guardian or a standby guardian, ideally they will also appear because the court may have questions for them. The respondent should appear if they are able to, although the guardian ad litem also can make recommendations as to whether or not they think it's in the best interest of the respondent to appear.
And how long would an uncontested hearing typically last?
Uncontested hearings are generally pretty quick. I've had some as short as 5 minutes. Usually they're more like 10 or 15 minutes. Although you're not necessarily the first case called. While they're doing video appearances, often you'll have a specific time that you'll be called, but when they're not doing the video appearances, you show up at the beginning of the docket, just wait till your case gets called. It usually takes about an hour for most cases on average, I'd say.
Andrea, are these hearings today conducted with everybody assembling in the Prince William County courtroom?
We do have the opportunity to meet before the judge in the courtroom. However, and all those hearings occur on Fridays at 10:30. We also have the opportunity this past year to utilize WebEx, and that would be a set time which would have the hearing, and those are generally starting at 11:30, also on Fridays. And we have had some attorneys request just to call into the court at 10:30 a.m. and have the judge take up the matter. This is particularly where you may have clients who aren't comfortable with electronics or coming in person to the courthouse. And so we've utilized phone hearings as well.
So what happens, we've been talking about uncontested, so what happens if it turns out that this turns into a contested guardianship or conservatorship?
Contested guardianship or conservatorship case would arise if the respondent objected in any manner. If they said, I don't want somebody getting in my business, or I don't like that person, I don't want them being over my decisions or over my financial. And so in any instance where a respondent objects, the court is required to hire a separate attorney for the respondent. So now we have 3 attorneys in the case: the petitioner's counsel, the GAL, and the respondent's new attorney. Those parties' attorneys generally meet and try to hopefully work out the issues, and if not, goes forward to a complete trial, which would require discovery and a hearing date, which can be by jury if the respondent elects, and that trial may not happen for some time, possibly a year out.
Oh my goodness. Well, let's talk about continuing with the discussion as an uncontested, let's talk about the court order. The objective in initiating this request to be appointed a guardian or conservator is to obtain a court order approving your request. Is that court order some sort of form document that a judge just stamps as approved?
Many of the terms for the order are dictated by the Virginia statute, such as a lot of the information we've been required to put in the petition. However, what's going to happen about this individual is unique to that individual. And those terms are discussed between the counsels and the clients, respondent and petitioner, to put in place what's appropriate for that individual. It could be making arrangements to change housing or living situation, to move to another state, to protect their monies in some manner, like a special needs trust. Could also ask for special permission to do mental health evaluations or commitments in the event of someone with serious mental health issues. So it's very particular.
Now, so Andrea, I'm going to continue. Does the court order, once it's signed by the judge, confer any authority on the person appointed to act as guardian and conservator? In other words, can I take that court order and walk across the street to Mom's Bank and present that, and will Mom's Bank allow me to do something with their bank account?
Close, but you got one more step before you step into the bank, and that is to see our probate clerks. And they will swear the person in to do the job and give them the appropriate qualification paperwork that they will need to go into Mom's Bank and get the bank account.
So the bottom line is that we're not quite done. Even though I've got the court hearing and I get a court order signed, I'm not quite done yet.
Correct.
So let's go to some common problems and pitfalls. As you look back over what we've discussed so far about this Prince William County process to request appointment of a guardian or conservator, you know, what are some of the common problems and pitfalls in undertaking a request to get such an appointment? Joe, I'm going to go back to you and get your thoughts.
So starting out, I think one of the biggest things that I see is we talk about getting these documents prepared in advance so you won't have to go through the process. And it's really getting help before going through the process for both creation of documents or if you need to go through the process. There is a lot of legal fine print that you have to comply with in order for all of this stuff to be effective. So trying to do this on your own is a big pitfall because there are often things that the ordinary citizen is not going to know about, not going to know to look for, which are really going to hinder their ability to draft documents, prevent you from having to go through the guardianship conservatorship process. And there are also pitfalls with drafting a petition and notices and orders and all of that that's required for an actual formal guardianship and conservatorship process.
Andrea, how about yourself? Any particular pitfalls or problems that you see in this process that folks should be aware of?
Common problems in this area are really focused around communication. Have folks communicated or tried to communicate with the respondent what they're planning to do? Yes, we know in some cases of dementia and some other mental health illnesses, this will be a difficult topic and will be upsetting to the respondent, but it's also upsetting when a stranger called the guardian ad litem shows up and says you've been sued in a lawsuit for somebody to be appointed guardian conservator. So laying the groundwork, also laying the groundwork within the family, because we have to notify interested family members, they also get concerned about somebody coming in and being overbearing and whether this is necessary, et cetera. So family conversations are very important at the beginning.
Well, we're getting close to the end of our time this evening. So, what I take from this, there are a lot of moving parts in this process, and this initial program only really scratches the surface as to all that goes into making the process work. Each family situation, of course, presents its own set of dynamics and challenges. Hopefully, our viewers appreciate that this is a process that is complicated and should only be initiated with the assistance of legal counsel. It really is not something you should undertake to do on your own. Now, Joe and Andrea, we're at the end. I want to ask you to share some final thoughts, words of advice, some practical suggestions regarding our discussion so far this evening. Joseph, how about yourself?
So I think the most important thing is probably to plan ahead for an eventuality like this, and at the very least, talk to your family members about what you want, talk to them about what they want, and have discussion with others in your family to decide who's willing to do what, who's best suited to do what. That way, everyone can be taken care of and everyone can feel good about the process.
Andrea, how about yourself? Some final suggestions?
Cost can be a serious concern in cases like this. The initial cost for just filing the petition can be expensive and the involvement of 2 attorneys, but contested cases can get quite expensive. And again, usually if families have talked about this, there may be a better understanding and resolution could be achieved. Even if the respondent disagrees with the need for the guardianship and the conservatorship, we try to best protect their needs. But cost should always be a concern for folks. So lay the groundwork, have the discussions, pre-plan if you can, but if you can't, get an attorney who's familiar with doing these type of cases.
Well, I want to thank both of you folks. We're really out of time. I want to thank both of you folks for taking the time to share your expertise and advice in part 1 of this particular program. It's a great service to the community and certainly to the Prince William County community. And I hope that you'll come back and continue our discussion as we move on to part 2 in a future show. Thank you very much. If you need to petition the Prince William County Circuit Court for the legal authority as a guardian and conservator, what our guests shared in part 1 should be incredibly helpful. Clearly, there are numerous steps to take to get your request to court so a judge can rule. And many of those steps deal with legal requirements both in the documents filed and in decisions to be made. But this show tonight is only the beginning of this discussion. In part 2, our guests will complete our education as we head to the probate office, get officially qualified to serve, and then board the living probate train. We encourage you to tune in for part 2. This brings us to the conclusion of our show. Hope it was informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.